So I beg to move that the bill be now read a second time. Since the amendments in 2007 to the Land Title Strata Act, my ministry has continued to consider public suggestions on how to improve the Act further. As part of our review, we have also consulted with industry experts such as academics, lawyers, property consultants, redas, and representatives from the Strata Titles Board. This bill is a result of that exercise. In 1999, the LTSA was amended to provide for en bloc sales to be completed with majority consent. Depending on the age of the development, the criteria for majority consent is now pegged at 80% or 90% based on share values and floor area. More than 10 years have passed since we made this amendment to the Act. There have been a variety of completely opposing viewpoints expressed on this as well as other aspects of this particular piece of legislation. Some have criticized that the policy of allowing en bloc sales undermines the property rights of individual owners, resulting in homeowners being evicted from their homes against their wishes. There have been calls for a revision or reversion to the pre-1999 regime, where unanimous consent was required for an en bloc sale. Others have called for restriction of an en bloc sale by majority consent to only much older buildings or if there are structural defects. And yet others have argued the opposite, that the consent requirements for en bloc sales are too onerous and that we should in fact lower the requirements further. There have also been calls for procedural requirements to be relaxed even further. For example, there have been strong calls to scrap the 5-day cooling off period and the requirements to have a lawyer witness the signing of the collective sale agreement by flat owners. Our approach has been to do what we believe is right as between the competing interests. Each owner has a right to live undisturbed in his flat and has the right to decide whether to sell or not to sell his flat. At the same time, majority views on whether there should be a sale of the development should be recognized as well. And there is public interest in intensifying developments and rejuvenating older developments. These different interests need to be balanced. The proposed amendments seek to achieve that balance further to the 2007 amendments. The LTSA serves as a framework for all strata owners, be they pro-sale or anti-sale, to jointly decide whether to carry out an en bloc sale. The government monitors the en bloc sale market and, where necessary, will refine the Act as we are proposing to do today. I will now highlight the key amendments. First is the amendment to have the Strata Titles Board, or STB, focus on its mediatory role for en bloc sale applications. Currently, the STB assesses all en bloc sale applications that have achieved the 80 or 90% majority consent requirement. This is to ensure that each en bloc sale transaction is done in good faith and complies with the provisions under the LTSA. The STB executes this role by both mediating and adjudicating on objections filed by minority owners who are against the en bloc sale. In recent years, a number of such sale applications have become highly contentious, with objectors raising questions on points of law ranging from fiduciary to constitutional law. Despite the best efforts of STB to mediate and adjudicate, a significant number of these cases have ended up in the High Court and even the Court of Appeal. These complex cases have resulted in protracted proceedings at the STB, and that has strained the STB's resources and has also affected its ability to consider other applications promptly. We therefore propose that the STB focus on its mediatory function for en bloc sale applications. This will allow the STB to devote its attention to mediate on the relatively straightforward cases. If mediation is successful and all objections to an en bloc sale application have been withdrawn, the STB can proceed to issue an en bloc sale order. To prevent undue delays and give greater certainty to the mediation process, it is proposed that the STB will be given up to a maximum of 60 days from the first day of mediation to try and resolve any objection for each application. For contentious cases, when it becomes obvious that any further mediation is not going to be useful, the STB may issue a stop order to conclude the mediation process. Majority owners can then choose to apply to the High Court for adjudications. There has been some public concern that this amendment will make it more difficult and costly for minority owners to file objections to an en bloc sale application. The fact is that in contentious cases, the process is likely to be long drawn, and parties may have to seek legal representation if they want to pursue every avenue. That is already the position now. After the amendments, minority owners can continue to file their objections to the STB, and the STB will then try to resolve any disagreement through mediation. If there is no resolution at the STB mediation stage, the STB will then issue a stop order, as I mentioned earlier. If the majority owners do not proceed to bring the case to the High Court for adjudication within 14 days of such a stop order, the en bloc sale application will lapse. If the case is brought before the High Court, objectors can then decide whether they wish to continue with their objections to the sale. This new regime will apply to applications that are made to the STB after the new Act has come into force. Other than this set of amendments, we also intend to amend the Land Title Strata Act schedules, which are subsidiary legislation. Some of them are of considerable public interest, and I'll refer to them. We will amend the Land Title schedules, or Land Title Strata Act schedules, to impose stricter requirements for owners to restart en bloc sale attempts if there has been a preceding failed attempt. In recent years, there have been growing complaints against pro-sale owners, especially, and I quote, en bloc raiders, close quotes. These raiders will repeatedly try to initiate en bloc sale attempts, even when they have failed to get sufficient support from other owners in previous attempts. Our view is that such repeated attempts, especially frivolous ones, should be discouraged. If there is no prospect of an en bloc sale succeeding, then owners should not be harassed. Nor should owners be sought to be worn down or be subjected to attrition tactics. The owner's right to live in peace and not be subjected to repeated attempts should be respected. We therefore propose to introduce a 2-year restriction period starting from the date of a failed en bloc attempt. Currently, an en bloc sale attempt can be initiated by convening a general meeting, where owners will decide whether to form a collective sale committee and to elect members to this committee. The Act already stipulates that such a general meeting shall be convened as long as there is sufficient support from at least 20% of the owners by share value or 25% of the total number of owners within the development. Currently, this 20% or 25% requisition rule applies even if there have been prior failed en bloc sale attempts. Hereafter, if a strata development encounters a failed attempt and the 2-year restriction period kicks in, the first retry to convene a general meeting to form a new sale committee will need to meet a higher requisition level of 50%, either by share value or total number of owners. If there is a further failed attempt within the same restriction period, subsequent retries to convene a general meeting to form a sale committee will need to meet an even higher requisition level of 80%, either by share value or total number of owners, i.e., there must be a high degree of certainty that the proposal will succeed before a general meeting can be convened. The 50 and 80% requisition levels will only apply to general meetings to form a sale committee. For all other general meetings convened for the purposes of the en bloc sale, the existing requirements for a 20 or 25% requisition level will continue to apply. At the end of the 2-year restriction period, the requisition level will revert to the original 20 or 25% requirements. These new rules will apply to all strata developments in which there is a failed attempt after the new legislation has come into force and the schedules are amended. We will also amend the schedules to expand the requirements for owners to declare their interests if they are standing for election to a collective sales committee. Currently, candidates must declare if they have interests in any property